In the long shadow of Britain's courts, some trials shaped and defined the legal landscape. From Tudor halls to Georgian benches, these judgments forged the law we know today. These are the cases that changed history. England. This case about a slave would change the course of history. This is the story of the case of Somerset versus Stewart. It started in 1769. On the shores of West Africa, a storm gathered, both in the sky and in human affairs. Among the many taken that season was a boy who would later be known as James Somerset. His story would travel farther than any ship that carried him. By night, lanterns swayed aboard vessels bound for the colonies. The Atlantic, restless and vast, bore witness to a commerce that transformed lives into cargo. Each wave erased another trace of home. Across the ocean, in Virginia, Somerset entered the household of Charles Stewart. He served as a valet, a symbol of his master's wealth and of the empire's reach. To those who saw him, he was property. To himself, he was still a man. But then, Stewart took Somerset to London. Somerset was baptized and took a Christian name, James. Yet baptism did not bestow liberty. Even faith in this age was bound by ownership. Somerset walked through the city as thousands did, anonymous among crowds, obedient, unseen. London, a capital of ideas and industry, remained blind to those who served its comfort in silence. In 1771, Somerset was seized in a London alley and placed in irons. His master intended to ship him to Jamaica for resale. It was then that his friends, ordinary men and women, resolved to intervene. In a modest home, lit by candles, the Quakers John Walkin and Thomas Davy drafted a petition. Their ink carried conviction. No man within England should live enslaved. The movement for one became a cause for many. Granville Sharp, a self-taught scholar and abolitionist, guided the legal effort. A writ of habeas corpus was issued, demanding that Somerset's detention be justified before the King's bench. The question was simple, yet immense. Could a human being be property under English law? Coffee houses buzzed with argument. Some spoke of liberty and conscience, others of commerce and precedent. The case of Somerset divided polite society as sharply as it united reformers. At the docks, a ship waited to sail. But the writ arrived first. The law, once a shield for the powerful, now paused in the service of a single man. In 1772, the case came before Lord Mansfield, Chief Justice of the King's Bench. The courtroom was crowded, barristers, merchants, clergy, and curious citizens, all eager to witness the trial that questioned an empire. Counsel for Somerset argued that slavery was unsupported by any positive law in England. Without statute, they claimed, the condition could not exist. It was a plea not merely for one man's freedom, but for the moral authority of English justice itself. The opposing side spoke for Stewart. They urged the court to see the matter as one of property and trade, not humanity. To abolish slavery here, they warned, would shake the colonies and their commerce to ruin. That night, Mansfield walked the corridors of his home in Bloomsbury. He knew the law offered little precedent, yet conscience pressed upon him. What he decided might alter not only one life, but the very course of British history. In the taverns by the river, sailors and traders debated the case over ale. Some mocked the notion that a black man could stand equal before English judges. Others, quietly, began to wonder if the world was changing. From pulpits and meeting houses, Quakers and evangelicals began to speak with growing boldness. Their message was simple. Liberty was not granted by Parliament, but by Providence. Weeks later, the court heard its final arguments. The galleries overflowed. The air was tense. Somerset stood still, as if the weight of every chain in the empire rested upon his shoulders. In solitude, Mansfield reviewed his notes once more. Every line balanced reason against consequence. He understood that words written tonight might echo for centuries. On June 22, 1772, Lord Mansfield delivered his judgment. The state of slavery is so odious, he said, that nothing can support it but positive law. It is so odious that it cannot exist. The decision freed James Somerset and in time awakened a nation's conscience. Church bells rang. Crowds gathered outside Westminster Hall. Pamphlets proclaimed victory. Others whispered of economic doom. But for one man, and for the principle he embodied, the world had tilted toward freedom. Somerset left the courthouse quietly, fading into the morning light. No guards, no master, only the sound of his own footsteps on the cobblestones of London. News travelled to the colonies. Plantation owners read it in disbelief, abolitionists in hope. In Virginia and Jamaica alike, the judgment was both feared and admired. Far away, enslaved men and women toiled as the sun set. Few knew Somerset's name, yet the air itself seemed to change. A rumour of freedom had crossed the sea. In Britain, new societies formed, the Society for the Abolition of the Slave Trade among them. Somerset's case became their rallying cry. They saw in it not an ending, but a beginning. Maps of trade routes once marked with profit were now reconsidered in light of conscience. The empire, vast and wealthy, had glimpsed the limits of its own power. Centuries later, historians would unroll those same parchments, brittle now, but still legible. In faded ink, they found evidence of a moral awakening. Today, in Westminster Abbey, a statue stands in Mansfield's likeness. Most pass by, unaware of its significance. Yet every judgment since bears some trace of the courage he once found. In the shadows of London's old port warehouses, rusted shackles remain. Reminders that progress is not erasure, but memory. Years later, lawmakers returned to the question. The Somerset ruling had not abolished slavery, but it had changed minds and opened doors. Artists would later depict the moment as scales tipping toward light. In law and in legend, the case came to represent the first measured victory for human dignity. Granville Sharp, together with others such as Olaudah Equiano and his Sons of Africa organization, continued the reform work, believing the pen could do what no musket ever had, set men free without bloodshed. The news of Somerset's case stirred others. Abolitionists in France, activists in America, campaigners in the Caribbean. An idea born in one courtroom began to traverse continents. Decades rolled onward. Each generation reinterpreted Somerset's freedom in its own context. What began as legal reasoning had become moral heritage. Finally, in 1833, Parliament passed the Slavery Abolition Act. 50 years after Somerset's release, the law at last aligned with the spirit of the case of Somerset versus Stewart.